Welcome to our present state versus history on Speaker. Here we are focused on the current events of our culture through the principles of our history, trying to make sense of the culture and the mindset of today. I am your host, Ray Mayfield. Okay, folks, it's February the 2nd. My goodness, 2022. It's like 21 degrees outside. I don't know where you are, but in southwest Missouri, we got little ice, a little freezing rain, a little sleet, usual kind of stuff. A little further north, got a little snow. Perfect day to be inside. After 30 years of being out in this weather and fixing these old junk trucks and crawling around in the snow and the sleet and the rain, I like sitting in the house looking outside saying, ain't that pretty? Anyway. Anyhow, folks, we've been talking a little bit about the judicial system in our courts. Our little president and his announcement he made here a few days ago has got us spurred back into some of those things. And we talked a little bit about the Supreme Court here the other day, and we'll talk to you a little bit about the jurisdiction of the Supreme Court and the federal ideology that was in the very beginnings of these stages when they was building our Constitution, trying to put this country together, and some of the arguments that they were having that have come to be exactly what we're dealing with today in this court system. If we had stayed with some of the basic, simple operations that they intended for us in the beginning, we wouldn't have a lot of the problems that we have today. But there again, I don't claim to be no scholar on judicial systems or law or anything like that. I'm just a simple guy that can read and understand what I read, and been going through some of these documents and trying to comprehend the ideology between the debates back and forth and why they came to the conclusions that they came to. Not looking for really any kind of objective, if you can say, to support one argument or the other, just trying to understand why they came to the conclusions they came to and what the validity between the points that were made is. And, the original intent for the jurisdiction of our federal court system was really pretty simple. By design, they knew that quarrels between the states obviously needed a third party to be able to come to, a conclusion of those matters, and arguments with foreign countries, legal matters that the states individually couldn't deal with on their own. So we got a federal court system that should be taking care of the differences inside and outside of our country, and they should be making sure that the stuff that Congress is doing is constitutional. And that's basically a real point or brief overview of it, but one of the statements that was made during the Constitution Convention was that the courts would be obviously dealing with matters in between the inferior courts from time to time as Congress permitted it, basically, was how it was worded. So they never intended for the federal court system to be all ingrained into our local court systems and all of these things on a regular, continual basis, And I found some interesting things when I was digging around through here about our numbers of justices, I guess you could say, that sat on the bench. And the first court that was established had a chief justice and 5 others. And then in 1801, it was reduced to 4. So we had the chief justice plus 4. In 1802, we had the chief justice, and that went to plus 6. In 1837, chief justice plus 8. 1861, we had the chief justice plus 9. 1866, we had the chief justice plus 6. And then we always get into that 1900 generation where we got all the shenanigans that got started. 1937, Franklin Roosevelt, he tried to put 15 on the courts. because he wanted to use the court system to push policies and programs through for his New Deal. And that didn't work out. But you see what happened right there. 1937. Here we go. So before I get into anything further on that, I can see a problem right there with we have the assumption. You see, our forefathers assumed some things that went along for, hundreds of years that were accepted in our society. But as you see the change of the thought process in our society start to develop around that 1900 system, we start to see different ideologies creeping in. We start to see some of these things that Mr. Jefferson especially was the most fearful of in dealing with things like our court systems and the other aspects of our Constitution. So we've got these things going on here. So the question that arises to my mind there is, okay, there's something maybe we need to fix right here. Maybe we need to establish how many justices should be on the bench and put a limit to the overall number of them. Maybe. I mean, it looks like here we got along with 4, 6, and 8, and 9 for a long time. Why do we need to even consider anything more than that? We had here just this recent election time. One of the big things I remember, they was running around afraid of different ones getting into the presidency, of packing the courts. They said we're gonna just do what Roosevelt tried to do. We're gonna shove a bunch of people in there that fit our agenda, and then we're gonna push this court system into, doing the things that we want to do, and basically make them legislators, which is what they're not supposed to be doing, or make them advocates, which they're not supposed to be. So there's one problem that would be easily solved, wouldn't it, with just a simple little limit to the numbers that can be on there. Just put it in writing, make it happen. So anyway, one thing that they did accomplish in the 1900s, though, is they did pass a bill that allowed the Attorney General to appeal directly to the courts whenever the constitutionality of Congress was involved. So you say, well, what difference does that make? Well, it makes a lot of difference, because now we have a direct access for the political agenda people to push into the court system and start to flood the court systems with appeals and with litigation. And I believe it was Madison. I might be wrong on the argument there with who it was, but I'm pretty sure it was Madison was afraid that the appeal system would become abused, and it would become the solution, if you will, for the means. Because if we can drag a court case out and never have it really settled, and it just becomes flooded down into the appeals, then we can wear things down, and to the point to where, we don't really ever establish a right answer. And that sounds exactly like what we got going on in our court system today, isn't it? They intended for the court systems to be separated. They intended for the states to deal with their own things and not become this litigation thing where whenever somebody goes to court and doesn't get the answer they want, they just appeal and appeal and appeal and appeal. And that's what they were afraid of. And the purpose of having the national or the federal district courts, I guess you could say, the jurisdiction within the states, was because they were concerned about people being able to get their cases brought to the national level without having to travel all the way to Washington, D.C. And so, that part of it makes sense. And but within the federal districts, we're supposed to have the states moving, which is the states should be dealing with the local aspects of things, and the federal courts that are within the states should be dealing with the national issues at hand within that state. See, and it's really not that complicated when we leave things in those simple formats, but it's when we decide that we want to corrupt these things, which is what Jefferson's biggest argument was about the human nature and wanting to expand their things. And it's not always just the evil, because when you have a good judge, after all, you want that judge to do right by everybody, right? So they expand the authority and everything gets out of control. And just little by little, it becomes a bigger machine that's harder to control. And that's exactly what we've seen happen. throughout the years through all this encroachment, I guess would be a good word to use for court system. But it's important that the court system is independent, but at the same time, the independence has to be kept in check. And see, that's where it appears that the forefathers kind of dropped the ball, mainly because they were afraid of things that were going on and repeating what was going on in England. But Wilson and Hamilton, they were large advocates, if you will, or very outspoken in the debates and in the conversations that were taking place about these judicial systems and how these things should operate within each other. Now Hamilton, though, he was a little bit more trusting, I guess you could say, than a lot of the others. Well, especially Jefferson. Hamilton, he believed that the judiciary. Well, in fact, one of his quotes, part of one of his quotes was, he says that the judiciary has no influence over either the sword or the purse. No discretion either of the strength or of wealth in a society. It can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficiency of its judgments. So Hamilton, he believed that because there was no authority given outside of the judicial system and other than just making judgments, that it didn't have any kind of power to get out of line, if you will. He believed that because they had to rely on the executive branch, which is the presidency, for any kind of support, and needed the other offices or branches of the government to come alongside in order to accomplish any kind of activity, that even its judgments could be basically pronounced as useless if nobody acted upon them. So he believed that in itself was going to keep the judicial system under control and prevent them from moving outside of the bounds where they were intended to be operating. But Hamilton, he didn't think that they could go Roe at all. He didn't think there was any way for him to get beyond that. But Jefferson, on the other hand, he objected to this thought process massively. And in fact, in the last podcast we did, we're talking about some of the arguments, if you remember, where Jefferson was talking about the natural man's desire to have power and to continue to expand that power and to move beyond. And these are some of the arguments that he was making concerning this subject right here. And let's see, I had part of a quote. Here's part of a quote from Jefferson. He's worried about the Constitution being subverted. And he says, man is not made to be trusted for life if secured against all liability to account. So in other words, if a person is secured in whatever they do against all liability or accountability for the choices and things that they make, that they cannot be trusted for life with that decision. See, this is the point he's making about the gradual influence of the will of man and in these positions of power and influence. And we've seen these things corroded away. And in Jefferson's arguments, he talks about term limits for the judges. And after a little bit of time had went by, you could see that things were moving in the direction that was not beneficial to the country. And there's another quote here I want to find here that I found from Jefferson. in dealing with the subverting of the Constitution,